Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the Petroleum and Minerals Pipelines Amendment Bill, which seeks to restrict bail to anyone who damages or sabotages supply pipelines for petroleum products. To discuss the issue, I have with me Mr. Vibhu Bhakru, Senior Advocate, and Mr. Anand Dayal, Advocate in the Supreme Court. Now for the headlines. Intentional damaging underground pipelines can lead to death sentence. Bill seeks to make grant of bail almost impossible. Even for anticipatory bail, the prosecutor will be given a chance to oppose bail. And the bill empowers officers to the extent that any finding by them will be considered true and the burden to prove otherwise will be of the accused. Petroleum and Mineral Pipelines Amendment Bill seeks to increase penalties for offenders caught sabotaging pipelines to supply petroleum products with death sentence if required. Since the management of pipelines has implication on the energy security of the nation, the government intends to amend the existing law to deter security threats to the pipeline installations, including those from extremists and terrorists.
Majority of the petrol pumps and gas stations depend on road and railways for transportation. But then there are several that depend on the underground supply pipelines for their need. And this network of pipelines has been growing every year. Despite regular patrolling and inspection of these pipelines, large number of incidents of pilferages and sabotage of anti-social elements are taking place. To curb such incidents, the government intends to amend the existing law.
The thinking of the government seems to be that the government has not been able to tackle the menace of such destruction or theft of these pipelines, and it has chosen to put in this kind of an amendment to tackle that. The biggest criticism that I can find from a legal perspective is that what the government sets out to do, the amendment actually doesn't even address.
According to the bill, whoever causes any unauthorized connection or damages any pipeline to extract petroleum product or minerals may be punished with rigorous imprisonment (RI) for up to 10 years and fine. If any is caught repeating the same offence, may be punished with rigorous imprisonment for not less than 3 years and up to 10 years. Whoever intentionally sabotages any pipeline being used for transportation of crude oil, petroleum product or gas to will be punishable with rigorous imprisonment of minimum 10 years and up to life or death. The bill also seeks to make provisions to make these offences cognizable and non-bailable.
I'm sure this bill will be subject to some challenge because it does give powers which are fairly draconian to officers. So I'm sure they'll be subject to challenge because they do interfere with the rights of a citizen. You are now making every officer effectively a police officer. You're also further saying that he can arrest and there will be no bail until a prosecutor is present. These are serious inroads into the rights of a citizen, and therefore I'm sure they'll be subject to challenge.
According to the Ministry of Petroleum, India will have over 30,000 km natural gas pipeline grid connecting all consumption centers in the next 5 years. Besides expansion of these pipelines, installation is expected for streamlining supply lines for crude oil and petroleum products. The basic methodology to check the petroleum pilferages is through pressure measurement. The pressure at which the refinery release must match with the pressure at the outpoint of the petroleum pumps. Most of the times, these kind of activities are either innocently ignored by the operators or they may join hands with the petroleum thieves and do this corruption. Rajkamal Rao for Rajya Sabha Television.
The Parliamentary Standing Committee recommends that the stringency of the bail provisions proposed could be made applicable only to the offences relating to sabotage of pipeline. That's a point. But my first question to you, Mr. Bhakru, is does the bill achieve what it sets out to achieve?
I don't think so. I don't think so for mainly the reason that you're preventing bail. You're effectively saying that once a person has been arrested, he is not going to be let loose without a trial. The idea of effectively dealing with pilferage would be to have conviction. you must convict a person, you must try a person. And really this is to have pilferages is only a minor part of this whole racket, because these are petroleum products, they are not products that are available off the street. So there will be a market mechanism whereby somebody will pilfer it out, he will sell it to another person, finally it will come down to a retail level. So there's a whole gamut of areas which you must crack. Find one person who's found red-handed pilfering or who's in possession of some material, and then give such draconian laws, in fact, would be counterproductive.
My question to you, Mr. Dayal, is, that's a point well made. Do you think, the way the bill is fashioned, do you get a feeling that the government is convinced that conviction is something which is very difficult to get, and at the timelines that are already prescribed? Since conviction is not happening, it's always best to deter the violator or so-called person by keeping him behind bars. Do you think, is that what the government intends to do by this?
Well, I think the undertone of the bill certainly is to try and make life easier for the government to get convictions, because they've done a couple of things. They've broadened the scope of the offence. They've introduced new offences other than what's under the IPC, specialized offences catered towards this sort of activity. And they've also introduced these presumptions in terms of burden shifting of the burden of proof, which all goes towards making life for the prosecution easy. But I think I would agree with you, sir, is that after all, this theft of petroleum product and theft in a pipeline does not happen in isolation. There is a broader context, there's an aftermarket for this, and so it's really the people who are responsible for this are more likely to be criminal syndicates rather than individuals. And the way the bill runs, and the focus tends to be as though it's individuals who are doing this. Actually, it's part of a larger group of cartel, a sort of criminal conspiracy, and so some of those things need to be also included to really make it an effective bill to curb this menace.
Coming to you, Mr. Bakru, do you think on the ground level, the way the police, the government has empowered its officers, it will eventually lead to detention of largely what section of people? People in villages who are not aware of this law, people who are drivers, attendants, and the lowest rung of the entire so-called organized crime, or as Mr. Dayal pointed out. But if that is what the bill is going to do, then what's the point when it doesn't deter the big fishes?
See, increasing a punishment from 3 years to 10 years is not any different deterrent. It's not as if 3 years is easily acceptable to a person who's put in jail and 7 years will not be, or 6 years will not be. So the deterrent is already there. The question is, you must get 5 or 6 people who have committed that offense behind bars who are actually guilty.
Yes.
And with it find out who else is guilty in perpetuating this market. If you can do that, then you will have a deterrent. But by saying 3 years, 4 years, 5 years, essentially it's not to say that if I had 40 years imprisonment for a particular crime, it will be more deterrent than 10 years, because I don't think people's minds work
that way,
that far.
And also they've also included, for the same effect's sake, I think they've also got in the life bit and death. It is just for the effect's sake. Coming to you, Mr. Dayal, the pipeline and the way it is done, here the bill specifically says that any property that is taken, recovered by the officer will assume to be whatever the records reveal. For essentially, if it's a corporation which is running a, let's say, a tanker, and if that tanker is caught in pilferage activities, stealing oil from the pipeline, then that responsibility will be on the corporation.
Right.
How does it really help this situation?
I think what the way it helps is by preventing or foreclosing a defense, because on the part of the accused, because if somebody is caught with petroleum product and it's obviously stolen product, he could, in a court of law, challenge his conviction, saying, you need to first prove that this does not belong to me, or this belongs to the corporation. So that's what earlier I pointed out. It's making life easy for the prosecution by building these presumptions in, so that if you are caught with petroleum product and it belongs to a certain, and it's presumed to belong to the company, to the government, and that you are actually in unlawful possession of that, because that essentially removes that ground of challenge if there's ever a conviction on a person. But I would also tend to agree that, you know, the proof of the pudding is in the eating. You need to really bring about some enforcements, and serious enforcements, where it's not low-level people, truck drivers and mistris who are caught, but people very high up, because ultimately stealing petroleum from a pipeline is not a joke.
Absolutely.
You know, it's something that requires a technical
organized-
expertise,
yes, yes.
organization, and probably collusive elements within the company.
Yes. It's time for us to head into a break. When we come back, we will talk about how the bill seeks to restrict bail to the accused. Welcome back. The Petroleum and Minerals Pipelines Amendment Bill proposes to restrict grant of bail to those involved in offence of damaging the pipeline. The bill also seeks to shift the burden of proof of not guilty on the accused and makes companies accountable for the defects in supply of petroleum products.
Since the enactment of the existing law, several underground pipelines have been laid across the country carrying crude oil, petroleum products and gas. The network of such pipelines has grown in a big way. India consumes 2.5 to 2.8 million barrels daily. In order to meet its needs, India imports about 72 million barrels of crude oil every month.
Arrest, investigate and prosecute, as if all three powers will become subsumed in one individual, and he will be responsible for the entire investigation and then to also prosecute a person in court.
The bill seeks to confer the powers of arrest, investigation and prosecution on the central government officers. In a situation the officer seizes petroleum product carrying vehicles and instruments suspected to be stolen from the pipeline, then the burden of proving that they are not stolen property will be on the person from whose possession the property is seized. If the recovered petroleum product is the property of any corporation, then the bill empowers the court to presume that such petroleum product belong to the corporation, and the burden of proving otherwise will lie on the corporation. The bill also provides for stringent provisions for restricting bail of the accused by including provisions that public prosecutor must be given a chance to oppose the bail application. The bill provides that the accused may get bail only when the court is satisfied that there are reasonable grounds to believing that he is not guilty and that he is not likely to commit any offence while on bail.
Person who is ultimately going to administer it from government is going to be no different from the person who administers law otherwise. He comes from essentially the same society. So if he is essentially given to some level of corruption, then the powers that you have vested with him would probably only enhance that.
The Unique Identification Authority of India and Petroleum Ministry signed an MOU in 2010 to curb the petroleum pilferages in the public distribution system. Bharat Petroleum, Indian Oil Corporation and HPCL will act as registrars for these kind of operations at the grassroots level to curb the pilferages in gasoline and other forms of petroleum in PDS system. The bill also ensures that the accused doesn't get a chance to apply for anticipatory bail by clearly providing in the bill that the relevant section of the Criminal Procedure Code will not apply where there is an accusation of stealing petroleum products from pipelines or sabotage of pipeline. Rajkamal Rao, Rajya Sabha TV.
The Parliamentary Standing Committee has asked the government to lay down clear provisions for the exercise of the above powers in order to prevent the misuse of these powers against innocent villagers or landowners. The committee recommends that the incorporation of suitable safeguard provisions in the bill must be made to regulate the powers of central government officers. My question to you, Mr. Dayal, is, see, there's going to be pressure on the person who will be empowered with such powers under the legislation to perform. He will be, if I'm an officer and if I'm given these powers to seize, investigate and prosecute, I'll be under pressure to perform. I can't be sitting without prosecuting or without seizing or without not doing these three things.
Right.
Now, since there's going to be pressure, do you think I as an officer will most likely show some activity, and in order to do that, I will apprehend the lowest strata of?
I think there is a very significant danger of that, because you've vested these draconian powers within one person who may or may not have the background and the qualification to exercise these in a careful way, because see, tampering with criminal legislation, particularly the right to bail, is a very tricky subject. And then when you vest these powers in one individual and you put pressure upon him to perform, he's going to get at the person who's lowest in the totem pole. He is not really going to go for the big fish. And because why? Because the big fish would stand up to him, and he'd have to explain why he did what he did. And so there is a real danger of what you describe happening, that the prosecutions go down to the lowest level.
So the data keeps coming into the government that this is the kind number of people who've been apprehended. The government is happy here, and the prosecution happens of the lowest segment. So everyone goes back happy, and the pilferage continues. Is that what we are looking at?
Yes, to some extent, that's what we are looking at. But more than that, I think the danger here is a little more significant. It's not simply that you've invested one person with police powers and said you can now do it, and every other central government will now assist you. Every officer of the central government will now assist you in doing this particular act. It's really a paradigm policy shift. What is the policy that you want? Do you want a policy where you presume persons guilty of offenses even before they have been tried?
Yes.
Is detention prior to trial and conviction to be used as a punitive measure? That's the policy change. And that's the danger. If we shift to this and start presuming, not only, one offset is that probably the lowest persons at the lowest rung will probably be arrested. And like it said, the other persons may just stand up to it. But look at the other way. There may be some serious businessmen who have possibly some animosity. They may be harassed also. So it probably cut across all economic lines in one sense. But the shift to the policy by saying our police hasn't done the job, it's already been a crime, but we haven't been able to catch these people. Therefore, because the police hasn't done it, we are now going to invest our officers with police powers. This policy shift is very pernicious, and I would think a very dangerous trend if you have to follow it through.
Policy shift. This is actually in the last few legislations that we've done here, this is one of the constant factors where in almost majority of the laws, they're shifting the onus of proving or the burden of proof on the accused, which now exists with the prosecuting agency. Is the government convinced that prosecution agency that we have can't do or can't perform in the existing set of laws, and the court is also, the way it is going on, is not really satisfactory? Is it because of these two reasons that the government has made this policy shift?
I think partly that's true, because the government wants to make its life easier and get convictions. But I think they've lost sight of some very fundamental things. The UN Charter, of which India is a signatory, one of the fundamental rights is you're innocent until proven guilty. And to try and water that away through, just sort of, it's like death by 1,000 cuts. And then the whole fundamental concept which is enshrined in the Constitution, the UN Charter of Human Rights, is just being through the back door circumvented by saying, okay, the burden of proof is shifted to you. We can hold you in detention without bail. And that eventually becomes somebody punishing the accused without a fair trial.
So basically, your liberty is taken away, and it's as good as death. It's time for us to head into a break. When we come back, we will show you an interview with senior advocate Abhinav Vashist. Welcome back. My colleague Rajkamal Rao spoke to senior advocate Abhinav Vashist and tried to understand the reasons behind the tough legal framework to restrict bail.
On the investigation part, we are finally depending on one particular person who will identify the crime, and who will he can presume that if a crime is going to happen, he can go and he can have a right. Do you think this is justified, sir?
Person who is really not a trained investigator, he is not a trained police officer, and he will perhaps open himself, because he may have to become the complainant in the case, he may open himself to threats and as also physical injury, including death threats, and maybe even the chances of being killed by the persons who are genuine culprits, who are accused of this crime.
Sir, many PSUs and a lot of large and big companies are involved in this petroleum business. How the prosecuting officer's protection is there? Does these amendments suggest any protection mechanism for him?
This bill is absolutely silent about that. That person, it seems, unfortunately will have to take care of himself. So how many people will come forward with such kind of complaints is highly debatable.
What is your take on the amendments proposed? Do you think these are strengthening the capacity of the government to catch hold of these thefts, or is it just a draconian law?
Increase the punishment which will be imposable on various parties who are held to be guilty ultimately after a trial. And they also have a very interesting provision, I find, that people will not be allowed to get anticipatory bail without the presence of the public prosecutor, or which is the government agency person, who will be able to oppose the bail plea of the culprit or the accused at that time. And that's a novel provision which has come about.
How serious is the problem of pilferages, sir?
On a daily basis, the problem is escalating. The pipelines have increased in number and length over the last few years, and accordingly there is bound to be, and we have seen that there is a trend of an increased amount of pilferage happening, and that is going to cause a lot of loss. More importantly, not only is the loss in terms of natural resources, if there is a pilferage, there can be leakage. Leakages result in environmental damage. Plus, these are pipelines which, if left unprotected, and if there is not enough deterrence in terms of punishment, there is also the chances of terrorists or extremists acting by blowing up pipelines.
The Parliamentary Standing Committee expressed its apprehension that the provision for the death penalty should not be misused. My question to you, Mr. Bakru, is, I mean, everything is so draconian, this, that and the other. What's the good aspect?
Well, one thing, there is a presumption that if you're found with petroleum goods, it must be presumed, unless you can show some paper trail to be stolen. If you can show a paper trail otherwise. I think that works because, like it said, petroleum products are not some products that you can just create out of nothing off the shelf. And even if you go to a petrol pump and buy petrol, you will have a receipt. And that brings about transparency. So if there is a truck that is found with petroleum products, he should have the paper trail to show where has he got it from. And to that extent, if he can't even do that, then I think the presumption works, because then it would be expecting too much to say, well, you can't show any paper trail, you haven't figured out where you bought it from, but nonetheless we will go about presuming, proving that you have stolen it. To that extent, this, as far as recovery of the stolen asset is concerned, I think it works. This provision works.
Yeah, Mr. Dayal, reporting of violation, you wanted to make a point on that.
Yeah, I think enforcement of these laws is a challenge, and anything we can do to help the law enforcement is helpful. One of the tools for law enforcement is creating an affirmative duty to report violations. Very often, I think, particularly in the case of pipelines, there are people who are in the know. They may not be part of the criminal syndicate, but they might be knowledge within the organization, and to turn a blind eye to that, I think should be made an offense, because that places, just like in anti-corruption, one of the requirements under penal code is that if you find that a bribe is being paid, you have a duty to report that offense. So similarly, that makes life easier, because what happens is, if you are investigating this and you find that people were aware of this and did not report that, that acts as a deterrent. It forces them to report this and bring it to the attention of the law enforcement.
So what you're saying is non-reporting should also be included as an offense.
Correct.
And on the stolen good recovery, the point you were making, Mr. Bakru, and the provisions that are already existing, this is one segment, Mr. Dayal, that you think is very crucial to the entire business.
Absolutely. I think, see, stolen asset recovery does not merely end at the petroleum product itself. It is also the proceeds of the sale of the petroleum product, the money. So I think that it's very important to sort of keep your eye on the money, follow the money trail, because that is really ultimately going to lead you to the big fish. And by using stolen asset recovery, or what is called civil forfeiture, the burden of proof is lower, because to get a criminal conviction, you need to prove beyond a reasonable doubt. Civil forfeiture, you just need to prove by the preponderance of the evidence. And it's an in rem, means it's an in rem proceeding, means it goes towards the asset itself. And so you can get at these assets, you can recover them, Plus, you can follow the money trail and get to the real people who are behind these syndicates.
Right. One last question to you, Mr. Bakru. See, we've got a whole set of gamut of laws for this and that and everything. But this law stands out because it's insulated from all other influences. So there's no connectivity between this and the other. And any such possibility of connection with the IPC has been severed by making provisions. Do you think this style of legislating will actually work in achieving deterrence, in conviction, in investigation, in all the aspects of whatever this legislation sets out to?
No, I think you hit the hammer on the head, in the sense is that it seeks to isolate this act.
Yeah.
Well, that in any case can't work, because the simple question is, supposedly there's a sabotage of a dam. Is it any less heinous than
Sabotage of pipeline.
sabotage of a pipeline? A terrorist activity to disrupt a rail track, which may cause severe loss of life. Is it any different from creating a sabotage of a pipeline?
Yeah.
The intent being of disruption. If that is what one needs to deter, then it has to be across the board. You cannot isolate one act and say, for this there will be death penalty if
And
you are
for
found,
that, it will
and
be
for
10
that,
years.
and for this there will be no bail, but that the normal procedure of court of civil procedure criminal procedure will be followed. This sort of isolation was, I can only term it as arbitrary.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.